the matter of Aviva Insurance Limited and another, and the Secretary of State for Work and Pensions.
Yes.
Here's the court. The fair balance test. Before I come to that, may I just mention something about a case I mentioned yesterday, which was Hassel and the Secretary of State, because it was referred to by the Select Committee. We've handed in, I hope you have, both that case and in fact another one which took it further because it was some over to comments in Hassel. To take it shortly, these were claimants under the 1989 scheme, which had by then become the 1992 consolidation, who already were in receipt of benefits when they had the relevant accident or relevant disease. And the first, in Hassel, there was an attempt to persuade the Court of Appeal that the scheme could be read in such a way, of course long before the Human Rights Act, that they didn't suffer effectively by having to have the benefits that they would have received anyway taken out of their damages.
Right.
And the Court of Appeal in Hassel said, sorry, that doesn't really work, but right at the end, per curiam in the holding, on the factual assumption that they would have been unemployed over the whole recuperation period during which they were in receipt of recoverable benefits, what they lost and should have claimed in damages against the tortfeasors was their entitlement to non-recoupable benefits over that period. So that was the point that was slightly
Sorry, no, that's 820, is it?
So I'm just looking at the head note,
Oh,
my lady, for this, because I don't think we need it.
Yeah, I'm sorry.
I mean, it can be looked at, but I
Thank
don't think the
I
reasoning
see.
really matters.
I see.
And the other case was Neil and Bingle that took that further and actually made a relevant award. And again, the head note I think is probably sufficient. That the plaintiff was already in receipt of benefit for an existing disability. He was injured in an accident. He continued to receive the same amount of benefit. And the Compensation Recovery Unit issued a certificate in relation to that benefit. And then dropping down to just below D, to avoid the possibility that his damages will be extinguished by repayment to the Department of Social Security for the amount specified in the certificate. The plaintiff also claims special damages in respect of the loss of state benefits, which he would have continued to receive in respect of his pre-existing disability, but for the intervening accident. And he did that, and the judge didn't think much of it, but this court allowed his appeal, and dropping down to just about letter H, according to the judge, should, in addition to the general damages and medical expenses, have awarded the plaintiff a sum equivalent to the benefits which he would have received but for the accident. And the figure is given. And the point about that is that those are slightly unusual, probably very rare cases where there is the identical benefit is already in payment. Certainly rare in accident cases, perhaps not so rare in a case like Mr. Carter, where he's got benefit for other reasons in any event. But of course, once the 1997 Act comes in, that problem disappears completely because of the ring fencing. It's only because there was no ring fencing under the 1989 scheme that.
Sorry to interrupt.
Well, the problem arose for the plaintiff.
Yes, but the effect of this judicial development was that the insurers ended up paying the ring fence sum anyway, which is the effect of the 97 Act, part of which has now been declared to be unlawful.
Well, yes, but that's because that was a straightforward application of the principle that the insurer pays, or the tortfeasor pays, for the loss of income flowing from the accident. A loss of income normally comes because you can't go into work. Sometimes the employer goes on paying and the tortfeasor gets the benefit, if he's not the employer. But in this very unusual situation, perhaps rather imaginatively, this court said, well, you can treat this as your loss of income that is not too remote from the accident. And all I'm saying is that that's an unusual situation and doesn't answer the situation in most cases. But the Select Committee, if I can just briefly take the court to the supplementary bundle, because this was part of the material put in by the defendant at page tab 11, page 62. This was the Select Committee report in 1995, and it's part of a section dealing with proposals for change. And
On 6.2.
well, no, 62,
Thank you.
lady. I'm sorry.
No, my fault.
And at paragraph 62, the committee say our proposed solution. Sorry, 68. Our proposed solution to the problems identified is modelled on the cases of Hassel and Secretary of State, and another case, Pether. And they explain what was going on in those cases. 69, we are aware that the facts of those cases above involve special circumstances of unemployed claimants, so that as the remarks in the cases are obiter, they are not strictly binding. Well, actually, Neil and Bingle then made it law. We therefore are not using the case of Hassel as a legal backing for our central proposal. Instead, we see the cases of Hassel and Pether as a model on which all cases involving compensation recovery could be based. And to take it shortly, they then proposed, and it would have to be a statutory change, that as it were on behalf of the state, the victim of an accident would claim the benefits and then hand them over. Now that proposal did not find favour with the government. After a consultation exercise, the approach adopted was the ring fencing one, which hadn't been suggested by the Select Committee, and that can be seen at page 155, which is part of the Department of Social Security's response to the Select Committee. And they 155, paragraph 4, in the consultation exercise, they simply refer to that proposal of a head of claim for the benefits, and then they seek answers to or views on issues raised. And at 157, they deal with contributory negligence, which was very much the focus of the problem of eroding claimants' damages. It was the very reason why some claimants took the case to the European Court of Human Rights, the Commission on Human Rights, saying it's unfair, the contributory negligence then means it eats into our general damages. And this was the focus, and so under the heading contributory negligence, paragraphs 9 and 10, the government has not decided whether contributory negligence and so on that they wish to take into account. And then 10, both the plaintiff and compensator would be made jointly and severally liable for the repayment of all prescribed benefits. Well, that was a sort of modification, it seems, of the Select Committee's scheme. But things moved on, and by, if one goes to page 159, now this is after this is another short paper. This is introducing the compliance cost assessment carried out by Price Waterhouse. And this is October 1996, so this is getting quite near to the bill going through Parliament. And they say at page 159, the government now propose that rather than create a separate head of damages to encompass recoverable benefits, a separate freestanding liability to repay such benefits should instead be placed on defendants. This is essentially a technical change. It has no effect on the compliance cost estimates, something we place considerable reliance upon, because when one looks at the compliance cost estimates, which happen to follow in this document, we see, and we invited the court to read the management summary. Price Waterhouse made an estimate of the cost of the separate head of damage. This is page 162. Management summary, item 3, the introduction of the separate head of damage. And so that's adopting the Select Committee approach, which is what they were instructed to consider, because this document is 1995, so it predates the one we just looked at. The cost, it would have a modest effect on insurance claims, estimated between 0.9 million and 5.2 million in a year, and some additional administrative costs for insurers. So it could be a £3 million in a full year. And then in contrast, paragraph Roman 4, the abolition of the small payments limit would have the most substantial effect on total insurance claims, increasing these by between 51 million and 66.9 million in a year. The additional administrative costs to insurers of bringing all claims, and then there's some administrative costs referred to. And so in response to that, the government said, well, we're going to change, we're not having this new head of damage, but we'll make the defendants repay the benefits, but it's a technical change having no effect on the compliance cost estimates, and that's, we submit, important and illustrative of the way in which no one was focusing on what we call the additional payment, or the payments that go beyond what we say are losses corresponding to matters which the victim could claim for. And as I say, focusing on contributory negligence. The key point we make about the
So
change.
you're saying that, I'm not sure, when you say there's a technical change, you mean that there's a technical change from the 1989 scheme?
No, I think I read it, I may be wrong, but as being a technical change from what had been discussed in the consultation exercise, which is that there would be a head of award. Price Waterhouse are asked to price it.
Yeah. I mean, that's the point they make in the first paragraph, isn't it? That
Yes.
the Price Waterhouse report is based on what the Select Committee was recommending, and the government's decided to do something different, but it's only a technical change because it achieves the same result.
Yes, exactly. And as we've seen from the management summary, that figure of 70 million or so, which my learned friend mentioned yesterday, is of course all about the small payment limit. That was the big change that was being made, and was the real prize for the state in recouping benefits because of the anomalous way it worked. So we have the situation that by the change that is made in 1997, we've covered this ground, in making this change, no one appeared to be suggesting that the benefits that would be deductible and therefore, and then handed on to the state, as had been the situation under the 1989 scheme, were somehow going to be different in character from what could have been deducted before. And bearing in mind that at common law, the deduction was on a like-for-like basis. So if you didn't cause a loss of earnings, then you couldn't claim credit for income support, for example. And then the change is made in 1989 to institute recoupment. And in fact, that works to the disadvantage of victims, because it is no longer on a like-for-like basis. The victims find it's, regardless, as long as it's a listed benefit, then it eats into their damages. And that was then seen as a perceived, rightly, as an injustice. And that change is then, that is put right in 1997 for the benefit of victims by this, what has been described as a technical change. And here we are, admittedly many years after the event.
Sorry to interrupt, but the technical change, you're right, there was a technical change from what the Select Committee had recommended. Yes. But the Select Committee's recommendation wasn't a technical change, because they had considered creating this new head of damages, which would then be effectively deductible. And instead they just short-circuit the process and just make the insurers all pay a compensated liable.
That's correct, but my lord, what this demonstrates, and we get this from the way Price Waterhouse costed the whole thing, is that no one seemed to be thinking that there would be anything, that the listed benefits would be anything other than making good an element of the claimant's damages, in the broad sense, that's why the cost to the industry of this separate right, obligation to repay would have this apparently modest effect. The rest of it was all about eroding damages and the admittedly anomalous position of the small claims limit. So I pass on rapidly from there. But my lord, lady, dealing with fair balance, the learned judge was responding. We can turn to his first judgment, paragraph 138, to page call bundle in tab 8193. he was responding under this paragraph 138.
And there's been no suggestion that this isn't a fair summary.
Exactly, that was my
Sorry.
first point. I didn't need to make that point. So there we are, we have 10 points. And one needs to bear in mind that when criticisms may be made of the learned judge, that he is actually dealing with specific points made by the defendant. And then the very first point is that the scheme was the subject of detailed consultation. So it was the defendants themselves who wanted to make a point about what had been going on that led up to the 1997 Act. And then the judge deals with the points in turn in paragraph 140, and it indented subparagraphs under each point. The first is the detailed consultation, and he says, paragraph 140, the effect of the legislative, the fundamental changes in the law could not have been in Parliament's contemplation. That's obviously true in relation to Fairchild in particular. And he then quotes Lord Hobhouse and Wilson about the way in which you deal with proportionality, where you have a change of circumstances. And then he says at the end of 143, paragraph 143, I conclude that justification has not been shown for the scheme as it now operates to ignore contributory negligence when determining the amount payable to the state. And so that's his answer to that particular point in that context. Paragraph Roman 2, 144, which was the point about it's a tax on insurers, effectively, and the state could have decided to tax insurers. He says, well, that's not such a scheme in 144. It's not a tax scheme, and he contrasts at the end of 145 the MIB and the DMPS, the Diffuse Mesothelioma Payment Scheme examples, and I've also mentioned other examples where, including the FSCS arrangements, whereby the insurers are paying for all these cases of missing or insolvent insurers, and under the Mesothelioma Act, they're paying indeed for cases where there was never insurance taken out. And Roman 3, he rejects the argument that the claimants could have adjusted their premia prospectively. He refers to Mr. Donovan. I don't think I need to say anything more about that. Roman 4 in paragraph 149, I'm persuaded that the estimated additional burden to the insurance industry referred to in the passage bill has turned out to be correct. I mentioned this briefly yesterday, just to recap. It's said that the judge makes an error here because the outturn has been, as predicted, some 70 million additional cost to the insurance industry. But that's not what Mr. Towers is actually saying. He's simply saying the overall take from all sources of EL and also all liability claims of recouped benefits is at that level. It's obviously gone down in relation to other accidents because happily we have we live in a safer world. But it's got nothing to do with the additional cost which flows from this aspect of the scheme which we criticise. And Mr. Harvey which I don't think Lordship saw, but there was a brief witness statement from him in the supplementary bundle, tab 5, pointing out that in contrast to the 49 odd asbestos claims that the Compensation Recovery Unit were recorded in 1996, Aviva itself had about, I think he said 250 in one quarter. And then he goes on in Roman 5, he deals with the 5-year rule. My learned friend has made quite a lot of this, and with respect, a slightly misleading way. The position is that the 5-year rule, to go back, there was, one can call it a windfall under Hodgson and Trapp at common law because the tortfeasor got the benefit, got the advantage of benefits being paid by a credit on a like-for-like basis, but without limit of time. That's taken away from him in 1948, but he still has an advantage of 50% and only for the 5 years. And then in 1989, it's taken away entirely for the 5 years because it's transferred to the state. However, both under the 1948 Act and thereafter, including this legislation, after the 5 years, the insurer doesn't gain anything. On the contrary, he still loses entirely his common law right of deduction under Hodgson and Trapp. Admittedly, the state doesn't get it back. It accrues to the benefit of the victim. So that's where the money goes, which is no doubt a good thing. It's not quite what Sir William Beveridge recommended, because he said there should never be double recovery. But to take the example of Mr. Bainbridge, my own friend mentioned that he received £7,000 of attendance allowance since the settlement of his claim. The way it works is 5 years is an upper limit. It's 5 years or earlier settlement. And so from the moment, if you settle after 2 years, then there's no deduction that can be made by the defendant, even though he will be liable for future losses. So in Mr. Bainbridge's case, his damages will have included the future loss of care.
Well, yes and no, because if you settle at a certain sum, you may lose benefits anyway.
Well, the answer to that is IADB is not means tested, and as your lordship pointed out, there are personal injury trusts which may take care of that situation. But the short point I'm making is that it's presented somehow as if a windfall is accruing to the insurer.
But in some respects it is, because your liability to continue to contribute to the losses you've caused has stopped.
Yeah.
The judge seems to say, well, because it came from an earlier scheme, I leave it out of account.
But I'm making a slightly different point, which is that we pay the damages. The insurer is undoubtedly liable for the damage caused. So Mr. Bainbridge's need for care will have been factored into the award of damages if it had gone to court.
It wouldn't be a claim for loss of future earnings.
No, he didn't have that.
Other future losses,
Yes.
you say are not reduced
Yes.
by reference to corresponding benefits.
Yeah. So if you take a straightforward accident case where there is a loss of earnings claim, then the loss of earnings may go well into the future. But if the claimant, either through a personal injury trust or because it's not a means tested benefit, is able to go on receiving his benefits, it's not the insurer who takes that to his advantage. And so it's a slightly misleading statement, given that the common law says, well, you only pay the net amount. That's what you've caused. It's not a scheme of punishment.
Well, that assumes the common law was right to take the approach it did in Hodgson and Trapp. And as a matter of history, it obviously was right, but things move on.
As a matter of law, we would submit it was right. And it was also what Lord Pearson said about the way in which what the tort is all about. And of course, it's the law of tort which is pushing always, prompting higher standards of care and all the rest of it, coupled with the statutory duties, health and safety legislation, and Factories Act. It's not the recoupment of benefits scheme which has any impact on that at all. And so we say, if one bears in mind all the schemes I've mentioned, starting with the silicosis scheme, and now the Mesothelioma Act, and all the efforts referred to by Mr. Towers, acknowledged by Mr. Towers, of the insurance industry to help with tracing missing policies, the ELTO scheme and the LCOP scheme and all the rest of it, it is not right to characterise this as some sort of compromise where there's a bit of advantage to insurers, a bit of advantage to victims, and a bit of advantage to taxpayers, but all of them also suffer some disadvantages. We submit that this is all taking things away from insurers, and therefore is, under an A1, P1 analysis, a deprivation of possessions without any countervailing benefit to them, which doesn't mean to say it's unlawful or disproportionate, but one does have to, that's the starting point. And then just to continue the in the judgment, so that's the 5-year rule. Paragraph 151 is the 3 features in relation to the 3 features, the first 3. And he then goes on to deal with retrospectivity, but in the middle of 151, he says the effect of the scheme as it now operates is to load onto insurers whose insureds under historic policies have caused varying proportions of exposure to asbestos 100% of the cost of the prescribed state benefits payable to the victims. These costs mainly arise under policies underwritten at a time when no potential liability existed to compensate. So he's identified the problem that this is rewriting of policies that were written long before there was even long before this idea of recoupment of state benefits existed. He then quotes Lord Mance in the AXA case, which we've seen about retrospectivity, and he contrasts, again answering a point made by the defendant in 153, the retrospectivity in AXA, why that was different, and he quotes in 154 what we've seen of Lord Hope's speech in AXA and about the difference there, bodily injury or disease. And then in paragraph 159 he deals with the small claims limit, and to that extent it could be regarded as remedial social legislation. I think that picks up a point my Lord Chancellor made yesterday. Well, that did put victims in a better position because they didn't have that dilemma of, do I take the £2,500 or do I fight on and get £2,501 because it's all, or even less potentially, because it was clearly an odd way, an odd scheme from their point of view. But then he says, the second sentence, however, insofar as it operates now to require payments by insurers to the state of sums that do not correspond to their insurer's contribution to the damage, i.e. the first three features identified in paragraph 11, it cannot be regarded as social and remedial legislation, nor as being comparable to legislation back in Finland. And we say that's correct. You can identify a discrete part of a piece of legislation and say that operates in isolation. The victims couldn't care less whether Section 6 exists. It doesn't affect them at all. So it does operate as a discrete and separate obligation on insurers. It might have been in a separate piece of legislation. And that's what the judge is doing, correctly saying, although you can say there's some the Act is remedying a social ill in one respect, it's not doing so by virtue of the matters that the claimants complain of. And then 9, paragraph 160.
Contributory negligence.
I've always accepted that's more difficult because
that is remedial social. That's where I was.
I'm sorry. Yeah.
Is not the change to contributory negligence
yes.
Remedial social legislation, because that's one part of which you.
I'm sorry. I should have said it's the ring fencing and the small claims limit, both of which advantage.
Yes, because I mean it was, if you were representing a claimant, it was difficult to explain the fact that they would then be losing the whole of it, even though they were only half of it was attributable. So that is a feature about which you complain, and does seem to me, subject to what your submissions are, to be remedial social legislation.
Well, what we say is the ring fencing, which is part of the earlier part of the legislation, and Section 8 remedies an ill, and in fact it restores victims to exactly the position they were under Hodgson and Trapp, because it was only a like-for-like deduction. So if they didn't have a claim for loss of earnings, the benefits were ignored. And so that ring fences their position. But again, in respect of that, victims couldn't care less whether the consequence of that ring fencing was that under Section 6 insurers paid over the full amount. It wouldn't impact on their position if insurers were only paying.
They didn't want to pay. 89 Act, they paid it.
Yeah.
97 Act, the insurers paid it. Well, fine in some respects, but that remedied the victim's position.
But it didn't. The point we're making is it didn't remedy it by saying you have to pay over 100%. It could have been remedied in a different way. It could have been remedied by a scaling down, or you could have simply had a like-for-like deduction, and then a like-for-like, and then the amount deducted paid over, and so that is the point I'm making. That's all I do make. That can't, because the scheme may remedy problems in one area, it doesn't have to go further. And then Paris 160 is the untraceable insurer point. But I've already addressed the court on that. 161 is the final point made by the defendant. He agrees the Welsh Bill observations are not strictly binding because they are obiter. Well, we're content to say that they are observations and analysis worthy of considerable respect because of the way it's analysed both by Lord Mance and by Lord Thomas in lengthy sections of their judgments, and he then quotes from Lord Mance at some length. And then 164 he says, in the present case, the 1997 Act does not build on established legal principles, it extends the liability. And all he means by that is that we've got to the point where the legal principle, that is common law, you have a right of deduction, but for reasons which were all to do with, we say, coming up with a scheme which was not the scheme advanced by the Select Committee, then you get this result. If the Select Committee's scheme had been the one presented, then if the benefits had been added to the damages, but there'd been contributory negligence, then the benefits would have been, that head of claim would have been reduced. And so the plaintiff's solicitor would then send a cheque to the state of the reduced amount. And so what was described as a technical change actually made quite a significant difference in making the payment direct.
So it wasn't a technical change on that basis?
Well, we say it wasn't, no.
It wasn't?
It was not. It's had this profound effect, which has only become manifest or really obvious, particularly since Fairchild.
Well, no, contributory negligence was from day one, minute one.
Yes, but the difference, I suppose, was that in contributory negligence cases, benefits are not that generous, so you would have to have usually quite a lot.
You didn't mind that much.
I'm sorry, Blaine.
You didn't mind that much.
No, I have to accept that, but it's not the same. We say as a Fairchild type liability or a divisible disease liability, which is not the injury sued for. That's the difference. Can I make one brief point before moving on to other grounds about what is said in my learned friend's skeleton argument in paragraph 131, I think it is, which is at tab 8. No, yes, tab 8, page 1.
Sorry, paragraph?
131.
Thank you.
It's under the heading scheme not incapable of operation in a proportionate way in nearly all cases. And my learned friend took the court to Lord Justice Hickinbottom in JCWI, and he himself, as indeed my learned friends do in their footnote, referred to a case called RBB and the Secretary of State. Can we just briefly look at one aspect of the BB case, because that was an immigration case, and it's at tab 41 of the authorities bundles, which I think will be volume 3. Put tab 41.
No, tab 4. Bundle 4.
I'm sorry.
Bundle 4. Yeah.
And tab
41.
Tab 41, please. And this was a case about the immigration rules and Article 8 of the Convention. And perhaps the argument doesn't need to be addressed, but it's if one turns to page 1706 and Baroness Hale, paragraph 60. She says, "I would not strike the rule, down the rule, or declare it invalid. It will not be an unjustified interference with Article 8 rights in all cases. It is capable of being operated in a manner which is compatible with the Convention rights. Hence, the appellants must be denied the remedy they seek. Just pausing there, I'll go on in a minute. The point was they were seeking to strike down the whole rule. And the immigration, yes, and the immigration rules have this odd character that they are not subordinate legislation. They are therefore not caught or covered by Section 3 of the Human Rights Act. There's no reading down obligation. They are simply an expression of policy, and therefore you don't need Section 3. You simply need to make sure that the Secretary of State complies with Convention obligations in the operation of policy. Because then we see Lady Hell goes on. However, the operation of the rule in the light of the present guidance is likely to be incompatible with the Convention rights of a significant number of sponsors. There may well be some benefit, therefore, both to individuals and to those administering the rule in declaring that its application will be incompatible with the Convention rights of a UK citizen or person settled here in cases where it is impracticable without incurring unreasonable expense for his or her partner to gain access to the necessary tuition. It's all about learning the English language to take the test. But this was not the remedy sought by the appellants, and we have received no submissions on it. I would therefore invite such submissions before finally deciding the outcome of this appeal. And of course, here we are in a different situation because you have legislation and we know how it operates at applying ordinary canons of construction. And that is how the Secretary of State applies it, because we know that from her technical guidance. And I think my own friend has passed on to the court the latest version.
Yeah.
And we say, no, the proper way is to make sure it operates in a way which is convention compliant, and therefore you have your Section 3 reading down obligation. So we are in a different situation. So although it's tempting, well, I understand why that phrase, a scheme not incapable of operation in a proportionate way in all or nearly all cases, looks as though it is an answer. It would, of course, pretty well disable Section 3 from having any relevance in most cases, because there are very few legislative schemes.
As you rightly point out, that was in the context of the scheme not being statutory.
Yes.
But if the scheme was statutory itself, then you would have had to read it out.
Yes, that's our short point.
Yeah.
And finally, on ground one, given the way in which it's put, which is focusing, we say, on the misdirection in relation to manifestly without reasonable foundation, based in part on a Supreme Court decision which postdated this judgment, SC. We say that even if my learned friend is right, that's not dispositive of this appeal, and the matter has to be considered afresh by this court, we would submit, by reference to the three features which we have identified. Turning to ground two, the error relating to the targets, I can take, I think, fairly shortly. It isn't simply Section 22. It operates.
Sorry to interrupt. I know Mr. Tankard is dealing with the authorities on
Yes.
MWRF.
Yes.
Will he also be addressing the question of whether or not what tests the judge did apply, and the suggestion that the judge implicitly substituted his own opinion rather than carry out a review? That will be part of his. So he won't just be doing the law.
Well, I think I will.
He looks thrilled.
He looks alarmed. But I better say something.
A fair run-in then.
I'd better say something about that.
Yeah.
What we say is, if the learned judge has correctly analysed what the aim, we say the mischief, whatever one word one wants to use, if he's got that right, then whatever one may say about the phraseology of the test, one shouldn't, we submit, get too hung up on phrases which are not statutory phrases. It was not manifestly, the way in which it operates, does not, the criticism that is made of it does not fail to reach the high standard of review that's required. It's a sort of negative, but given that the learned judge was not presented, of course, with arguments about manifestly without reasonable foundation in relation to anything but fair balance, and he has gone seriatim through the particular points that were made about fair balance. If he's got the aim right, he's right about rational connection, and he's with the defendant in relation to contributed negligence. He's right about no less intrusive. When he gets to fair balance, even though he was entitled, because of what Lord Mance said in the Welsh Bill case, to say, well, it's not that high threshold test. This isn't an irrationality test that he's having to apply. And what he's doing is pointing out that everything that is put forward by way of special justification, it has to be special justification, falls away when one looks at the reality, which is that the point was never considered at the time. The implications could not have been considered at the time. Got nothing to do with protecting victims. It's got nothing to do with spreading the risk over the insurance industry, because that's already dealt with by other schemes. And so we say that even applying that rigorous test, he would have inevitably come to the same conclusion. But that's why I said a moment ago that if it's a misdirection, it wouldn't be fair to the claimants simply to say, well, therefore the decision of the judge should be reversed. Ground 2 targets for judicial review. This is dealt with 133 onwards of my learned friend's skeleton argument, and it really is saying, well, it's all about section 22 of the Act, and to some extent it anticipates ground 3, which I will deal with under that heading. But 134, there's an alternative argument that any challenge had to be brought. This is a time issue. The short point is that the reading down obligation under section 3 is continuous. Every time anyone seeks to operate this legislation, if a convention, if it would operate in a way which is not convention compliant, then section 3 is mandatory. It's there's no discretion about it, unless it can't be done because it goes against the grain of the scheme. And if that happens, then you have section 4, declaration of incompatibility. There's no halfway house. So we say section 22 isn't the target, and in any event, as the judge correctly says, the way section 22 operates is on a day-to-day basis, indefinitely, as claims on these ancient legacy policies are made.
This does pick up, though, the question of the declaration, albeit along with the other ground, which is, I think, ground 7, of the date of the declaration that was granted.
Yeah, well, to the extent that they cover the same issue, that is correct. And we say that once you get to the point of the judge identifying a moment when the scheme was beginning to operate in a way which was disproportionate in any respect, then it became unlawful to go on mechanically applying the scheme without recognising that there was a section 3 obligation to.
Subject to the issue of limitation, which is
yes.
You have to bring it within 1 year of the relevant detail. So how could he go back and declare it unlawful if he's relying on Article 1, Protocol 1 to 2000?
Because of the analysis in O'Connor and British Standards Board, Bar Standards Board, which is that the section 7.5a time limit is by reference to the date when a continuing failure ceases, in contrast to the CPR Part 54.
But it ceased. This is why I've been going on about the certificates. I mean, it ceased in relation to certificates paid in 2001. In 2001, there was nothing more in relation to that policy. In 2002.
Well, my lord.
And yet, the declaration goes back to 2000, giving right to this argument under restitution.
Well,
why should we allow that to continue if it couldn't on any basis?
Well, let us say someone has been falsely imprisoned for 2 years, and he brings his claim within a year of the date he's released. And the circumstances that make it false imprisonment are continuous. There's no change throughout that period. One would expect the court to say, well, we looked at everything. This was unlawful imprisonment right from the start, because O'Connor and Borough Standards Board, it's the date when the unlawful
Yes,
behaviour
but
That's a
ceases.
completely different, it's not an appropriate analogy though. I mean, this is a case where each certificate when issued on your case interferes with your A1P1 rights. But it isn't until a certificate is issued that there's any interference.
Well, there is
And
this.
that's what the statute, I mean, the statute talks about the insuring clause, as it's put for shorthand, being
Yeah.
inserted in the contract, in the policy of insurance, when a certificate is issued.
Well,
Talk about it being done on the date the statute comes into force or anything like that.
No, but what we say is that if the judge had said, as he might have done, well, I'm only going to look at the situation going back a year, and he'd analyse it in exactly the way he does, and says, well, so contributory negligence and those cases, it's unlawful. We then issue a claim form for a private law claim for damages.
But you're not issuing claim form. You've got these claims for damages, which you've already said you're not particularising, and the government said fine, and I've already made my views clear about whether that was sensible. But you've got the claims for damages as part of this claim.
Well, my lord, yes, but what we say is that if the features of the case which make something unlawful within the previous year have been unchanged since the Human Rights Act came into force, then what harm is there in the court making that clear?
A lot of harm, because you end up causing absolute chaos in the courts trying to deal with class action litigation. You said it would have to be done on a representative sample. If 14 years worth have nothing to do with this because the certificates have been gone and paid and you didn't complain about it at the time, and
all claim time barred.
you can't resuscitate them or attempt to resuscitate them, as you very fairly have made clear you will attempt to do, going back 6 years before the claim form.
Can we look at the Human Rights Act just to make
Yeah,
a
of
point?
course, yeah.
Because it's at tab 7, in fact, volume 1.
7 in the Authorities Bundle 1.
Just as it were, going backwards at 156, there's the judicial remedies. Right, and you can get damages, but that is needed only if there's no other basis. So if you have a private law.
Well, and we're talking about Article 1, Protocol 1, so nothing is any good to you apart from damages, is it really?
Yeah, but we don't need to rely upon Section 8 if we have a Woolwich type or Climore Benson claim, a matter to be argued over in the future.
But well, it does interrelate with the question of limitation, and it might even feed into fair balance that no challenger was brought for a period of time. Perhaps not. But it does relate to the declaration the judge made, especially if you're going to argue the Woolwich point. Because if you're saying that actually in 2000 it was incompatible with my human rights, then we have to look at the issue of limitation.
Well, someone has to look at it. We entirely agree, but it's been left over, and that hasn't.
Where in an order is it left over? And it's not appeals from judgments; it's appeals from orders. And at the moment, you have an order simply saying it's unlawful from 2000, and a judge inherited
ignoring any limitation questions
Yeah.
or problems, just a
Just
straight statement.
But my lord, that's because a declaration that something is unlawful doesn't give you a private law claim in itself. It is only the first step. It's like a preliminary issue. So, and I gave the example of the European Court, which has pronounced on the unlawfulness of UK legislation.
But you're going to use the declaration of unlawfulness in order to piggyback your restitution.
Absolutely, we do accept that. But
So how can you skip the limitation in the Human Rights Act?
we don't skip it because this is a continuing, we say, failure.
Well,
we can bring the matter before the court.
But the way you've said it, that there have been lots of certificates issued going back, which is almost certainly true. One can
Yes.
almost take judicial notice of it and be common ground. But they go back to 2000.
Yes, but but again,
But as my lord put to you a moment ago, if you take a certificate issued in 2000 where you paid against the certificate in 2000, that's the end of it. There's not some continuing interference in relation to that certificate.
No, I accept
So
that.
what you can't do is to turn around and say, 20 years later, oh well, there's a continuing interference, so I can push these all
No,
back.
my lord, I accept that. And if we didn't have a sample certificate, Mr. Bainbridge, then we wouldn't bring before the court any recent occasion when it's happening. But having done that, all we've said is we entirely accept that the defendant has to be given every opportunity to deal with limitation in every respect. But let us examine, first of all, the lawfulness of the way in which it's been operated. And having got that far, the judge is not, and judges should never pronounce on purely hypothetical matters, but he's not pronouncing on a hypothetical matter, he's pronouncing on a matter which we say, maybe wrongly, will be relevant to a private law claim. That's all we're saying, and so that's why we rely upon O'Connor to say we brought a situation before the court, and the court has, that's the vehicle for the court to pronounce upon it. Just as Mr. O'Connor, no doubt, if he had some claim for damages against the Bar Standards Board, would have said, thank you very much, well, let's analyse it, and we will go back right to the moment when your unlawful act started. That's all we're saying. And the alternative is for the judge to have framed his declaration by reference only to current events, current matters, but we would still have said in our private law claim, building upon that, well, what was different in 2000? We'd accept in Fairchild there's a change, but what we would say rhetorically, what was different then, and how can you justify what you were doing in 2000? And here's our private law claim.
Well, except you can't, because in 428 you've actually asked for, as part of your relief, damages. You can't then bring a separate claim.
No, it's the same proceeding, but my lord, if one looks at what at the core bundle, where we set out, it's really recorded by the judge in paragraph 190, or 92, I think. Under the remedies, so 3.4, core bundle, 20. It's a skeleton argument.
It's 46 is the claim.
So it's foot 4, it's tab 28, the statement of facts and grounds.
Yeah, but just look at paragraph 71, it's compensation, which is 459, if that helps.
That's it. Yes, thank you. That was the paragraph. And so that invited the defendant to say, well, we don't agree with that it should go off on another occasion.
No, but this is what but I understand your complaint that they didn't do that. But we're looking at what the judge has ordered.
Yeah.
And you've made it clear that you're seeking an award of damages, including a restitutionary claim on the basis of mistake under payment of law, and relates to past payments made to crew in case where it was unlawful. And that goes back all the way to 2000.
Yes.
And the judge has given you that declaration. And at the moment, it might be thought you have a real problem on limitation going back to 2000.
Well, I accept that, but my lord, he hasn't given us the remedy. He's given us the declaration, that remedy. He hasn't given us the right to damages. Now, if it's a matter of the way in which the order is framed, then I suppose the parties and we, front row, should take responsibility because we drafted this order and the judge approved it. But what your lordship is identifying is possibly a lacuna in the order that could be corrected to make it explicit that there are these other issues remaining to be decided. But that's all. So the point I was making was that if we pursue a private law claim and this judgment stands, even if this court were to, as it were, excise those parts of the declaration that go back beyond a year before the proceedings were started, then we're simply going to say, well, look at Sir Justice Henshaw's judgment or the Court of Appeal judgment. What's the difference in 2000?
Well, the fact that you could have bought claim and didn't.
Well, that's a good. That will have to be examined under the Limitation Act, but not under the Section 7 of the
But
Human Rights Act.
limitation is one of the grounds of appeal.
No, it's well, it shouldn't be because there's no.
Well, that's why, I mean, it's not us that have presented what happened below and the grounds of appeal. We're just trying to work out fairly what we've got to decide.
It's a ground of appeal on which the judge gave permission.
No, well, what did that?
Permission on all the grounds.
Well, I'm not sure they were formulated. I think they may have been formulated in exactly the same way. But my lord, this is under the heading target of the.
Well, yes, that's why I said, and it relates to ground 7 as well.
Yes.
Yeah.
And that was a factual, well, not a factual matter, but a matter of analysis. When is the starting date? And also the justiciability point, because Section 22, they said, and we say no, it operates immediately the Act is passed and predates the Human Rights Act. But the judge, as has been pointed out, this is an appeal against the order, and so where in the order does the judge say anything about limitation? Well, perhaps he should have done, but we know in his judgment, his second judgment, he leaves that to be decided. So we would invite the court to say, well, that's a matter for the future.
Well, you're quite right, he did leave it to be decided, and you very fairly flagged that up in the judgment. But he also granted permission to appeal on limitation.
Well, I'm not sure. I'm not sure if your lordship's referring to the second judgment.
Well, ground 7 of what's before us.
Well, ground 7
It's not about limitation, you say.
that's the starting date, because the point was being made. Well, why are you going back? Well, we're not sure quite what is being said about it, but we understood this to be focusing on when it was that there was a significant interference as a result of developments in the law. Maybe I misunderstood what was being said.
Right.
Because we didn't, below, the defendant said, well, you don't deal with these starting dates, and the judge said, well, I will deal with that aspect. And no submissions that we recall were made in opposition to our submissions in the consequential skeleton as to when the starting dates should be. And we say HELP-B was pre-Human Rights Act. Contributing negligence obviously has always been there. And then Fairchild, we said, give everybody 6 months to react to the House of Lords decision.
We don't have the Limitation Act relating to Human Rights Act claims in the bundle, do we?
Well, it's only Section 7 of the Human Rights Act, because Section 7 is a limitation in relation to bringing proceedings.
Yeah.
And if you want to rely upon Section 8, which is a special Human Rights Act entitlement to damages, then you've got that 1 year.
Section 7 covers the claim for a declaration as well as the claim for damage.
Yes, you've got to, it's any proceedings.
Yep.
But that's why we say if you've got a continuing, O'Connor says it's the date that the unlawful act ceases. So that is why we say there isn't a limitation issue for this court to decide.
Well, we've got your submission that it's continuing all the way through.
Yes.
And you've got and you've addressed the proposition that each time a certificate is issued and paid, that's the interference.
Yes, exactly. So if I could, because I don't want to take up any more time on this, if I could then go to ground 3 is justiciability, but it's really, it's covered properly by the judge. He analyses the way Section 22 operates every time a compensation payment is made.
On the wording of the statute.
At that moment, the indemnity expands.
Maybe the right analysis is that there's an interference from the outset, and then either it's continuing, you would say, or it occurs every time there's a new certificate.
Yes.
But once the Human Rights Act is in force, and the bulk of the certificate is going to relate to the period after it came into force,
Yes.
then it must be justiciable.
Well, we said that's ground 3. Ground 4 is victim status. I can deal with Aviva first of all very simply. If the Department of Transport...
I don't think we need to hear you on victim status.
Thank you. And then ground 5 is the regulation making power. My own friend is now parking his section 6.6 point, dealt with by Lord Reid in the case of VT, and he says he also wants to. He's united him to take instructions on his section 6.3 point, the new point, and we say just look at the subsection. It's got nothing to do with regulations being made by the executive. It's got to do with what goes on by parliamentary staff and officers and so on.
And if it was right, would we be, I know that in this stage the claim is saying you should make these regulations, but if it was right, it would apply to regulations which have been made, which have been quashed by the courts in the past.
Yes. So that can't be right. One only has to look at wording. So I pass on then to an Article 9 of the Bill of Rights. We've really covered this. There's been a debate about this, but we're not criticising or impeaching Parliament. We are relying on that very narrow basis on materials which assist the court in identifying what we say is the aim or the mischief of the legislation.
Yeah.
Ground 7, the start dates. Well, I've already touched on that. There's been no argument on the merits of that. We understand as to why the start dates were wrong. And then ground 8 is reading down. And reading down is dealt with by, in the second judgment, really from paragraph 17 onwards. Guyden is the key authority, and I don't need to do anything other than invite the court to read what the judge says about that, because Guyden is important in that what the Supreme Court did in that case was make the explicit statement that the courts had been too reluctant to use section 3. And there were lots of unnecessary declarations of incompatibility. And I think it's Lord Steyne who has a table at the end of his judgment setting out lots of occasions when he's effectively saying, well, the court should have been bolder. And Lord Roger, as quoted by the judge, at paragraph, I think it's paragraph 18 in his supplementary judgment.
Paragraph 20, isn't it?
Is it 20, yes. He makes the point, the important point, that the wording of the section 3 is to requires the public authorities to read and give effect. And he says that's not empty tautology, that it has, and that's why you get to an example like the case of Connolly, which is at tab 29 of the authorities bundle, and therefore I suspect in volume 2, it could be volume 3. Tab 29. Volume 2, thank you. And this was the Malicious Communications Act case where a defendant in the Magistrates' Court sought to justify her sending really what appeared to be rather nasty material through the post, aborted fetuses and so on, in pursuit of her religious convictions. And so there was a tension between the Act and her Article 10 rights. And all I want to draw attention to is what Lord Justice Dyson, as he then was, says. He quotes at some length from paragraph 17 Lord Nichols in the Guyden case, and then at paragraph paragraph, which I think is at page 970. Paragraph 18, in the light of this guidance, I consider it is possible to interpret section 1 of the Act in a way compatible with Article 10. This can be done by giving a heightened meaning to the words grossly offensive and indecent, or by reading into section 1 a provision to the effect that the section will not apply where to create an offence will be a breach of a person's convention rights, i.e. breach of Article 10, not justified under Article 10.2. since the Act also applies to the sending of articles that do not engage any article of the Convention, for example, excrement in the post, it must follow that the effect will be given to Section 1 differently according to the nature of the communication that the article represents. And so, although my own friend has understandably referred to our rather amateurish attempts to reword Section 1 of the 1997 Act, which was at the invitation of the judge, by the time the case concluded, we rather gave up on that attempt and said to the judge, you don't need to do that. The court doesn't have to, it isn't a legislator, it doesn't have to reword the Act. It simply has to indicate the way in which the Act should be given effect. And so in this case, the Malicious Communications Act has to be operated by those responsible for prosecutions, bearing in mind what Lord Justice Dyson said. There'll be nothing that they can read to tell them, no qualification that's been written into it. And that's quite a striking example. And so we say what we complain about is at the margins, it's not going against the grain of the legislation for reasons we've discussed, and there's therefore no difficulty about the Section 3 obligation, which of course, as I've said, is a mandatory obligation. And then that brings me to our own appeal. This is really, given the time, it's covered in our appeal skeleton argument. And
Well, you say if you're right about everything else,
yes,
the judge's approach of salami slicing, only giving you 3 slices and not 4, is
Yes.
logical.
yes. And the key point was, in a way, it was our much more straightforward argument. What we call the excess
That's
payment.
part of the illogicality. It seemed to me. If you're right about the judgment generally,
Yes.
then it does seem to me that it is illogical to have shut you out on
Well, we say that, and one of the reasons why the excess or the additional payment obligation is straightforward is that was the direct consequence for insurers of Section 22 of the Act, because as I've said, under the 1989 scheme, there's no equivalent. Insurers, I don't think, are mentioned under the 1989 scheme. In fact, I'm sure they're not, and that's because all that is happening there is that the insurer is required to before he would write 1 check, now he has to write 2 checks. It's the same amount of money, it just goes in different directions. So I don't think any insurer ever took the point that that's not within the indemnity or the insuring clause of his policy. But in practical terms, he's only paying out what is in his tort visa was liable for.
May I ask one question on this, which is this point, because this is an appeal from Mr. Justice Henshaw, rather than us starting off from fresh, as it were.
Yes.
If you're right on 4, what does that say about our reliance on his appreciation of the fair balance?
Well, my lord, if my own friend is right, then we have a difficulty on our appeal about fair balance. But it is a slightly different question. It's different from contributory negligence. And the reason I say that is this. Contributory negligence, you've got damage which has been caused by the tortfeasor. It's just that the tortfeasor is let off paying 100% and pays 50%. Our complaint, and the learned judge may have misunderstood the circumstances in which this arose, that may be the cause of the problem, is the case like Mr. Bainbridge where there is no head of loss. So the state chooses generously to hand out taxpayers' money for people who don't technically need it for a particular head of loss. But then says, well, can we have it back from you when we say, well, we're insuring bodily injury and disease and the consequences of it, and we haven't caused that head. But if he was thinking of the contributory negligence example, where because it's squeezed down so much, the deduction under Section 8 still leaves a surplus, then one can see that in that case, he said there was a rational connection between the situation in contributory negligence and the legitimate aim. And we wonder whether that was the confusion and that he wasn't focusing sufficiently on what we call the pure excess situation, which is where, as a result of the changes in 1997, not simply because of ring fencing, this is the point, not simply because of contributory negligence, but purely because the state can add listed benefits at will and then say to insurers, adventitiously you've caused an injury, the benefit is in relation to that, to that. But in the case of Mr. Carter, for example, he was receiving it in any event and would have been because of his other conditions. That is the pretext for you having to pay us back. That is that situation which we say is needs to be specially justified, has not been specially justified. And that's all we've got is you need a bit of retrospectivity to deal with cases in the pipeline, but you seem to be meaning cases that have already been intimated. And it doesn't answer the analysis in the AXA case or the Welsh Bill case about retrospective interference with policies. And so we say that the analysis that the judge adopted, and we set it out in the skeleton, we can invite you to reread, seems therefore to allow a situation where the state simply on an arbitrary basis, it is arbitrary we say, recovers from insurers something which isn't their insured's responsibility at all. And that we covered that. Of course, we covered that in relation to contributing negligence, divisibility in a mesothelioma case under the Compensation Act. But the simpler way of doing it is to start with feature 4. We should have put that first and said, why are you making us pay more than we're deducting? And then give examples of circumstances where the surplus or the additional amount is not related to any injury which the insured has caused. I would propose to stop at that point and hand over to Mr. Tankle unless there are questions from the bench.
Thank you very much, Mr. Kent. Yes, Mr. Tankle.
I'm addressing Your Lordship's what I hope is a discrete point about the test to be applied in A1P1 cases, which is not the same as the test which the Secretary of State advanced, I think, on day 1 of the appeal. The absolute fundamental point to keep in mind at the beginning is that there's 2 types of A1P1 case. There's a case where you say the state has deprived me of a possession or controlled my possession in a disproportionate way, a straight A1P1 case. And then there's the Article 14 case, where you say the state has discriminated against me in a manner having to do with my possessions. And that test in SC about where it says MWRF, whatever MWRF means, permeates through all 4 stages of the proportionality assessment. That's relating to the Article 14 line of authority, not to the straight A1P1 case. So what is the test in the straight A1P1 case?
Why should there be a difference?
Well, a number of reasons. First of all, there is, when you look at the Strasbourg authorities and precedents. Secondly, the discrimination cases are inevitably dealing with controversial and invidious questions about which social groups should be prioritised over others when you're distributing benefits. Whereas a straight A1P1 case is a simpler inquiry about who should pay, not who gets paid. Second, under Article 14, the claim is a weaker type of claim. The claim of the victim is a weaker type.
A decision by the state as to who should pay,
Yeah.
your as it were, straightforward A1P1 case is just as much, or maybe just as much, and certainly Mr. Brown says it is just as much an issue of social policy in relation to which the court should exercise caution, putting it neutrally. I mean, you may be right that Strasbourg authorities seek to draw the distinction, but speaking for myself, I just do not understand the logic of the distinction. In a sense, if it were the other way round, I could see the force of it, because and then you know where the Supreme Court get to in SC is saying, yeah, well, it's not really, it's not an immutable test, and obviously, and say that the Supreme Court, where you have a suspect ground of discrimination, then you've really got to look very carefully indeed, and it may be that on one analysis that is not manifested without reasonable foundation, but there it is, that's what they say. But where it's a straight case of interference by, as it were, financial means, I just don't understand why some less stringent test applies.
Well, certainly the court has to give the state a margin of discretion, and I'll take you to the authorities which show how wide that needs to be.
Yeah.
Certainly in A1P1 cases, it tends to be wider than in cases involving other convention rights. And I'm absolutely not submitting that the court becomes a substitute decision maker. But the question is whether the discretion is as high as the MWRF test. I'm just trying to address Lady Justice Carr's question about why should there be a difference. I've got a few other reasons.
That's what the Strasbourg law says, and then you say whatever, controversial and different.
And that's why I picked you up.
And this is not a criticism, and I'm certainly not trying to be difficult, but I'm trying to root this in your skeleton. Is there a section on this? Because I haven't picked this argument up anywhere before, which is no doubt my fault. Where do you do MWRF in your skeleton on this?
What we do in our skeleton is say MWRF applies only at the first stage, not at the later stages.
Okay. So this is
because your skeleton predated the decision of the Supreme Court in SC.
Yes.
And at least one subsequent decision of the Court of Appeal applying it.
Okay. Anyway, there we are. Thank you.
Including one last week. Okay.
The other reasons why the test under Article 14 is a more stringent test is that the interference, the claim on behalf of the victim, tends to be a weaker type of claim, because the MWRF test usually applies in the context of entitlement to welfare benefits, and a claim to an entitlement for welfare benefit is a weaker kind of possession, if it is a possession at all, than a piece of land or a contract or a debt or a chosen action. It's not something that you hold in your hand.
But the cases put it really on the breach of Article 14, don't they? I mean, they talk quite often about breach of Article 8 as well, but they talk about breach of Article 14. Discrimination. This piece of welfare legislation discriminates against certain people with a protected characteristic.
Yes, and they have to. Those claims have to be pleaded under Article 14, because there's no freestanding right under the European Convention, under A1P1 or any other of the articles, to a welfare benefit. However, there is this halfway house where once the state has set up a welfare benefit scheme, it's referred to in the cases as falling within the ambit of Article 1, Protocol 1. So the possession, the entitlement, the expectation of a welfare benefit is not a full possession, it's within the ambit of a possession.
Yeah.
And once something's within the ambit of a possession, you're not allowed to discriminate against the individual. So that's the second reason why the test under Article 14 is a more stringent one, because the possession is a weaker one.
Do any of the domestic authorities draw that distinction that you just drawn?
Not that I'm aware of.
No.
And as far as the general approach to Article 1, Protocol 1, it's always been considered, there's no ranking of rights within the Convention, but it's always been considered a weaker right because it's interfered with all the time by governments through taxation.
Yes.
I mean, Lord Hoffman in Great Bay, in relation to the equivalent, said it was a weaker right in terms.
Yes, it is a weaker right. We're not comparing, in this case, this right with other types of right, but it is generally regarded as a weaker right. But when it's a straight interference, not as weak as requiring an MWRF justification at every stage.
So the answer, just so I'm absolutely clear, you're going to show us some Strasbourg authorities which draw this distinction, but none of the English authorities do.
The English authorities can be read as doing so.
Well, I understand, but there is a difference between, as it were, something that's in black and white in a decision, and what might be described as a gloss or an explanation which counsel seeks to put forward as to why cases, particular line of cases.
Well, I hope it will be clearer than just a gloss or a clever idea.
Jolly good.
But I mean, my final point on why it might be a weaker right is because all legislation discriminates. That was the point that was made in SC. It's always possible to say it benefits this person more than that person. So there's got to be some type of control mechanism. Now, can I just articulate at a high level what I say the test is in relation to straight A1P1 cases, and then show you authority for the propositions. So certainly the court will, the Strasbourg court breaks it down into a number of different stages, but the two which are absolutely critical for our case are what is in the public interest, stage 1, and stage 2, is there a fair balance struck between the public interest and the rights of the victim. Now, and that stage 2 is then broken down into the 4-stage proportionality analysis that we see in Quiller and Bank Melland. Now, on the first question, the court will normally respect the judgment of member states as to what is in the public interest unless it is manifestly without reasonable foundation. And that is a mantra which is repeated throughout the Strasbourg jurisprudence. And MWRF there is a way of describing the very low intensity of review that the court will adopt in assessing the legitimacy of the aim. It is up to the government, the state, to decide what is in the public interest. But then the court will go on to consider whether a fair balance has been struck, and in doing so, it will weigh up the competing interests, applying a margin of discretion. And the margin of discretion as applied by the international courts is wide, because member states, it's accepted at that level that member states are better placed to evaluate these sorts of inherently economic, social, political issues than an international judge could be. But in all of the Strasbourg authority, there is no reference at that stage of the test, the fair balance stage of the test, to the language of MWRF. And there might be a debate about whether in this context the discretionary area of judgment which the domestic courts give to Parliament is narrower than the wide margin of appreciation that Strasbourg will give to the member state. By contrast, in the Article 14 cases, it's it's a more compendious exercise where the whole of the justification part of the test is analysed through the prism of MWRF. Now, the starting point for all of this is the Welsh asbestos case at tab 38. Sorry, I don't know what the court's volume numbers are. And I know that Mr. Brown submitted either yesterday or the day before that what Lord Mance said in Welsh Bill is no longer good law because Lord Wilson in DA said it no longer stands. I'm going to take you to that in due course, but the short point about it is that Lord Wilson there was talking about the Article 14 context, not about what I'm calling a straight A1P1 claim. So tab 38, the Welsh Bill case, and we can pick it up at page 1482, paragraph 44, where there is this point about margin of appreciation, but we've got to analyse it from a domestic standpoint. Paragraph 45 refers to the four-stage test which we are seeking to apply in this case. Paragraph 46 is not well, at the end of paragraph 46 it may be that significant weight has to be attached to the particular legislative choice even at the fourth stage. And then paragraph 47, we start the recitation of the Strasbourg authorities. And Lady Justice Carr asked on day one, what was the Supreme Court looking at when it identified this test? So we have, it's paragraphs 47 and 48, we've got the full list of authorities. Now it's worth reading both of those. Paragraph 47 cites James. James, I think, was the first case in which the language of manifestly without reasonable foundation came up. And one can see that the question of the United Kingdom's Parliament's belief in the existence of a social injustice was not such as could be characterised as manifestly without reasonable foundation. But then this, however, does not settle the issue. Not only must a measure depriving a person of his property pursue a legitimate aim in the public interest.
So, sorry, but that's turning to the means chosen to achieve the aim.
Yes.
MWRF does not settle.
MWRF does not. Whether something is in the public interest does not settle the question of justification. Once the court has accepted or found that something is in the public interest, applying the MWRF test, you then need to go on to apply the fair balance. And you can see here a number of different mantras which are repeated throughout the remainder of the authorities. But nowhere there is a repeat reference to MWRF. It's a fair balance, it's proportionality, it's making sure that the individual doesn't bear an excessive and individual burden. And then paragraph 48, later authority, again, the court will accept the legislature's judgment as to what is in the public interest, unless that's manifestly without reasonable foundation. But an interference must nevertheless strike a fair balance. And then we've got a list of cases to which the Supreme Court had been referred. And all of those cases are straight A1P1 cases. So the Allgemeine Gold and Gassus dossier cases are about seizure and forfeiture. Pressos was a case about legislation which removed the right of certain claimants in shipping cases to a claim in damages. Back in Finland was about debt adjustment, reducing the notional amount of debt that certain creditors had over others. Granger in the United Kingdom was a post-2008 Northern Rock shareholders case about the nationalisation of Northern Rock. And Paulette and the United Kingdom, I think, is also it's about criminal confiscation orders. So all of those cases, deliberately, it can't be a coincidence, are all about A1P1s, straight A1P1 cases. And there's no mention of discrimination, no Article 14 claim in any of those. Now, carrying on in our Welsh Bill judgment, paragraph 51 over the page, domestic law is to like effect, and then there's a quote or an analysis of the decision in AXA. And it's interesting because 4 of the judges, I think it was a 5-judge court, but 4 of the judges in AXA held that you only apply MWRF when evaluating the state's decision about what's in the public interest, but not at the later stages. But Lord Brown held differently. You can pick it up at C. He held at paragraphs 80 and 83 that there should be a rolled up approach to the issues of legitimate aim and proportionality. That's the approach which the Secretary of State says now ought to be adopted here. But that was a minority view, if that even was the correct way of reading Lord Brown. And in any event, it was rejected again. So this proposition that you apply MWRF across all 4 stages of the proportionality assessment was rejected in AXA, if you want to call a 4-1 decision a type of rejection. But it was also rejected in the Welsh asbestos case because the Counsel General for Wales tried to make the point again, but Lord Mance didn't agree. And then Lord Mance speaking for the majority. And then paragraph, while we are here, paragraph 53 is a reference to the need for special justification in retrospective cases. And paragraph 54, an interesting paragraph which needs a little unpicking, but that at the domestic level the margin of appreciation is not applicable. The domestic court doesn't have the same disadvantages of physical and cultural distance as an international court. The fact that a measure is within a national legislature's margin of appreciation is not conclusive of proportionality when a national court is examining a measure at the national level. But nevertheless, domestic courts cannot act as primary decision makers. There's still all the same principles of institutional competence that apply. But the domestic courts might have an especially significant role in weighing up all the interests. I'll come back to this point about the discretionary area of judgment. Now, just at paragraph 105, which I think is on page 1499, Lord Thomas and Lady Hale with him agree with the analysis of A1P1 as set out in paragraphs 44 to 53, meaning they didn't agree about the extra level of interventionism that a domestic court might adopt, but they agreed with everything else. So this is the unanimous decision of the Supreme Court, that MWRF applies only when assessing the state's decision as to what's in the public interest. Now, one of the decisions which the Supreme Court had referred to it, we saw 5 or 6 there, but there's only one we've got in our bundle, which is back in Finland. Now, that's at tab 25.
Sorry, what, each tab?
It's, I don't know the volume numbers, I'm afraid, but it's tab 25.
Two.
And the reference in the Welsh Bill case was to paragraphs 53 and 55 of this judgment. So if you just take a moment to read those.
Back paragraph.
53 and 55, which is on page 807. So
So
again,
all about MWRF legitimate aim and public interest, but not in relation to proportionality.
exactly,
Simple as that.
simple as that. And then, not for now, but for later if there's time, paragraph 57 onwards shows the practical application of the second part of that test. And the high-level submission that I wish to make about it, and this can be seen in all of the authorities applying this test, is it's quite a hands-on test. So for however much they say wide margin of appreciation, in all of these cases we see real grappling with the justification being advanced on behalf of the state, and that's in the nature of the fact that we're now at the second limit, the justification stage. The state is advancing arguments, and those need to be analysed and grappled with. And see also PI, which is another European authority which we have in the bundle, and which I think my learned friend Mr. Brown relied upon. So that's tab 30, paragraph 75, page 996.
Paragraph,
Paragraph 75.
thank you.
And just, it's really just up to the end of the sentence, end of the first sentence on the next page. So the state enjoys a wide margin of appreciation with regard to both choosing the means of enforcement and ascertaining whether the consequences of enforcement are justified in the general interest. And in spheres such as housing, the court will respect the legislature's judgment as to what is in the general interest, unless that judgment is manifestly without reasonable foundation. So the same point.
But doesn't that though suggest that the full sentence beginning indeterminate suggests it's the same approach? It's the same wide margin of appreciation on both the questions which you seem to suggest carrying different tests.
The test beginning in spheres such as the sentence beginning in spheres such as housing is talking about the judgment as to what is in the general interest.
Correct, but in the sentence before that,
Yes.
Yeah.
It says it's talking about the
it's
consequence.
dealing with both the question of means of enforcement, i.e. proportionality, and ascertaining, and whether it's, and the question of general interest, and it's saying the same.
It's as to whether the consequences of enforcement are justified.
Are just exactly, so the general interest question is the same test is being applied to both questions.
I don't think it's not a general interest test. One is the consequences of the general interest, and that is a wide margin of discretion. And then the second is what is in the general interest in the first place.
Okay.
I just give you the references because I'm running out of my allocated time. The case, two cases were handed up on the first day, again in support of this proposition, by the Secretary of State. One was the Christian Religious Organisation, the witnesses case, and you were referred to paragraphs 44 and 45. I'll just give you the references, but there's no reference to MWRF in that case at all. I don't know why. They didn't even look at the public interest, but there's no reference there at all. And you were also handed up the decision of Mr. Justice Bourne, a recent decision in a local government pensions case. Paragraph 137 of that judgment, Mr. Justice Bourne does say, it's worth looking at. I don't know if you still have that to hand. It's all obiter and not in a fully considered part of the judgment, or in a less fully considered part of the judgment, I should say. But at paragraph 137, Mr. Justice Bourne does say, in terms, that the MWRF test applies at all 4 stages.
Have we got Steck?
I'm sorry?
Have we got Steck in the bundle?
No.
Because I think Steck does refer to manifesto without reasonable foundation, and I think that's what the court is referring to in 45 of the Jehovah's Witnesses case, where it says in that second sentence, for in matters of general social and economic policy on which opinions within a democratic society may reasonably differ widely, the domestic policymaker should be afforded a particularly broad margin of appreciation. See, for example, Steck.
I think Steck
I think if we look at SC, we'll see that's picked up in SC.
I think Steck may have been a benefits case, a discrimination case.
Right. So you say Mr. Justice Bourne was wrong, do you?
Well, all of the cases he cites are Article 14 cases.
So give me the reference in Mr. Justice Bourne's judgment.
Mr. Justice Bourne at paragraph 137. So DA is a benefits case. Drexler is a case about home to school transport. JCWI was a case about not renting properties to migrants as part of the hostile environment. They're all Article 14 cases. Unlike in the Welsh Bill case, where they were all straight A1P1 cases.
And the Enterprise Managed Service case was a straight A1P1 case.
Sorry, which case?
Mr. Justice Bourne's case was a
Yes,
straight.
it was.
Yeah.
It was.
So that is an example of a domestic case which decides MWRF applies in a
It is, but
what we describe as a straight A1.
it's obiter. Its first instance. It's not in as fully a considered part of the judgment as the remainder of the judgment, and all of the cases cited in support of the proposition come from Article 14 line of cases, not from the A1P1 line of cases. Contrast paragraph 38 of the Welsh Bill case, or 48 of the Welsh Bill case.
I mean, given, and I know where it come from because Mr. Brown made a great thing of this, can you tell me what is the practical difference between a wide margin of appreciation and something that is manifestly without reasonable foundation?
Well,
I mean, you're perfectly entitled to say it's Mr. Brown that set this all running, but that may be one of the reasons why it may not have been analysed in detail is because, frankly, it's dancing on pinheads.
Right, I was about to say, how many angels can you get to dance? Right.
there has to be a difference because even in SC, the final conclusion is that there's a thing called a margin of discretion, there's a thing called MWRF, and those will both mean the same thing in a case where an especially wide margin of discretion needs to be given.
So there may be no difference in practice.
In the
there
right
may
type
be.
of case. depending on the circumstances
Yeah.
of the particular case.
Well, it may be that they said what they said in SC to stop courts being, taken through a whole series of authorities.
Well, I mean, precisely, I mean, what Lord Reid says in SC at 160, it may also be helpful to observe that the phrase manifestly without reasonable foundation, as used by the European Court, is merely a way of describing a wide margin of appreciation. A wide margin has also been recognised by the European Court in numerous other areas where that phrase has not been used, such as national security, penal policy, and matters raising sensitive moral or ethical issues.
The question of the difference between a wide margin of discretion and MWRF is, the point my Lord has just made is one that I worry about in my darkest moments.
The question we have to address is whether this judge gave, putting it neutrally, gave a sufficiently wide margin of appreciation to the legislature in relation to this piece of legislation. So let's not get too hung up about whether it was manifestly without reasonable foundation or not, because at the end of the day, as Lord Reid says, it's essentially the same test.
Well, 2 minutes.
And there's no suggestion there that I can see in SC that, and I'm not criticising you at all, it's a very clever argument, but there's nothing in SC, which is the latest learning of our highest court on this subject,
well,
even begins to draw the distinction that you're seeking to draw.
well, it didn't need to, because SC is all about Article 14.
Well, yeah, that's what you say. Okay.
But
all
fair
right.
balance is, you're absolutely right, but to be fair to the Chancellor's point, fair balance is implicit in the whole of this jurisprudence, whether you go from Article 1 all the way up to Article 14.
Look, there's a jurisprudence which exists, and it seems to suggest that there is a difference between MWRF and a wide margin of discretion, even though those might end up in the same place in an appropriate case. I say this is not an appropriate case. See Welsh Bill case where it didn't apply in that way. See all the other A1P1 cases where it's not applied in that way. And see a number of other particular factors which arise on the facts of this case, which include retrospectivity, the fact that this is not legislation which directly benefits victims, but is rather revenue raising, and as the point Lord Mance makes in Welsh Bill case, that is a social problem of a different order, a need to raise money. The fact that the aspects of the legislation which we complain about are contingent developments rather than the subject of conscious parliamentary choice. And the fact that when Parliament has consciously applied its mind to the question, it has created different schemes of the type which are described in Annex 3 to our skeleton argument below. See Core Bundle, page 378. I do need to finish. I'm well over my time. But we say Mr. Justice Henshaw identified the correct test. If in his judgment he goes through the Welsh Bill case, he says that's the test. He didn't need to mention MWRF beyond that, because we conceded that the legitimate aim which the government was relying on was in the public interest. And then at the other 4 stages he didn't need to apply MWRF. And then, of course, it's going to be for this court to decide whether he afforded an appropriate margin of discretion. But basically, the exercise that he was doing was looking at the justification advanced on behalf of the government and going through point by point and asking himself, does that stack up? And questions about more general, high-level questions, is this a fair balance between this group of payees and this group of payers? They really fall out in the question of, is this social remedial legislation? And he decided, applying the Welsh Bill case, it's not, because it's a revenue-raising is an issue of a different order to direct rent controls or writing off debt. So he deals with it in that way, and it's exactly the same way that the Welsh the Supreme Court dealt with it in the Welsh Bill case, and all of the European cases which I've taken you to deal with it on the facts which were before them. I hope I haven't just been dancing on the head of a pin.
Well, it wasn't you that started the particular dance anyway.
No, but we are.
Okay.
I am stuck with the jurisprudence which exists, which does appear to suggest that there's a difference.
So you, just so I'm absolutely clear, it's what you infer, and you may be right, you may be wrong. Nobody ever says there's a different approach to be applied depending on. Then the answer is no, because you would have shown us.
No, the high point of my case
Yes,
is
what's the
look
high
at the
point?
Welsh Bill case. It's citing only A1P1
Right.
cases. Look at SC and Mr. Justice Bourne, and they're citing only Article 14 cases, and they arrive at different places.
Thank you.
Thank you.
Louis? No. My lord, I'll probably need about 30 minutes, possibly less.
Good.
MWRF, rather surprised that we're having the debate, and the judgment of the Supreme
Well,
Court.
we're going to ask you whether you were taken by surprise by any of that. Because we couldn't see it anywhere in the skeleton
No
argument.
supplemental skeleton or anything.
It's not the SC is not the latest word. It is a definitive statement, we would say, of how one applies MWRF in any convention case, and it very much does constitute a form of recalibration, perhaps, of what's gone before. It's building on a lot of learning from domestic courts and the Supreme Court, but
But it runs through, doesn't it?
It
All
does.
the various cases in which somebody's had a go at saying MWRF isn't the right test.
yes, and I accept that there will be cases when a more nuanced approach is necessary. That's what SC says. And what I sought to do before this court in my submissions was take you only to SC, because I hope that in this case and in any other future case, one only needs to go to SC and apply the nuanced test. And that although we didn't have the benefit of SC when we settled our written argument, is what we were saying at paragraph 84, obviously in summary terms and without any of the elegance of Lord Reed's judgment, when we say that the precise breadth of the margin afforded even within the MWRF test can vary. It will vary depending on the degree to which the constitutional factors mentioned above apply in the particular context, and it is not a binary question. Because that, it seemed to us, even prior to SC, was the correct statement of the law, and it's all been reinforced by the, as I say, far more elegant way in which it has been put by Lord Reed. But this is now beyond doubt in terms of the approach. My criticism of the judge is essentially that he hasn't applied the appropriate test of deference, and he has substituted. And that is the criticism which we make throughout ground one. And insofar as we have used MWRF as an abbreviation, then that perhaps sets a hair running, because it then starts to become a preliminary issue type question. That's not the approach. It's easier than simply writing the words out, but it has to be borne in mind, as we said in terms in paragraph 84, that it is a flexible test, and it's being put forward by our side as being a flexible test. It wasn't the test applied by this judge, because he didn't apply an appropriate level of deference, despite what he might have said from time to time, and he certainly substituted. He didn't appear to have applied any test of deference at all. It wasn't a review, it was the judge's own primary conclusions. So that's all I'm proposing to say about MWRF. The starting point of my learned from Mr. Kent's submissions was to revisit the point about whether we'd approached the issue incorrectly in terms of factual case. If I can just very quickly show the court Bank Mellet.
Sorry, if you'd approached.
Marlene, if I can show Bank Mellet, and then the point that I'm making will perhaps become clear. So that's in the authorities bundle, please. Authorities tab 36, page 1353, paragraph 20. if I can invite the court, please, to turn to paragraph 21.
Paragraph.
21 in Lord Sumption's judgment. So summarising the law, the way that it's put by Lord Sumption at the top of page 771, when considering the approach, their effect, so the effect that is of the rationality and proportionality principles, can be sufficiently summarised for present purpose by saying that the question depends on an exacting analysis of the factual case advanced in defence of the measure in order to determine 1, 2, 3, 4. But when Lord Sumption is saying one needs to look at an exacting analysis of the factual case, what that has in mind is that the court has to scrutinise the Secretary of State's evidence, their evidential case as revealed by the detailed grounds, and any witness statement served on the Secretary of State in support of the measure. So we say with respect that the insurers misunderstand the approach here, because what we have done in this judicial review, as indeed any other judicial review, is to identify the statute or the measure that's under challenge. In many cases, that will indeed reveal what the legitimate aim is, because ordinarily Parliament will be legislating in order to further legitimate aims. But we're not limited to the four corners of the statute, or indeed what's revealed by Hansard. We can indeed advance an evidential case, and Lord Sumption says this is in fact a question of fact. It's a matter of law. It's not a matter of law, it's a matter of fact. So that's the basis upon which we come along with the statute and say, look at the legitimate aims that are discerned from the statutory language.
Well, you say two things then. You say, first of all, look at the statute itself and the legitimate aim which you put forward in paragraph 115 of the, summarised in paragraph 115 of the judgment.
Yes.
Is demonstrated by the face of the statute, because that's what it says.
Yes.
So that's point one. Point two, even if you were wrong about that, you've got Mr. Towers' evidence about legitimate aim.
Yes, and it may...
Together with the other material that he exhibits.
Indeed, and that's why we avoid what I described in my submissions as the invidious trap, which is still pursued by the insurers, where they say you can't point to Fairchild in anything prior to 1997, and there's no statement recording the minister having Fairchild in mind, therefore you're shut out from any argument that might in fact be responsive to Fairchild. We say, well, that's not right in principle, see Lord Sumption, it's an evidential matter, but that follows as a matter of common sense. The statute's always speaking for 22 years. Why is it that the Secretary of State can't then in 2020 say, in addition to everything that was good in 1997, there are yet further compelling reasons for this statute, which have been identified in the period since then? And taking it further, because this is another point, what difference does it make if it's only identified for the first time in the detailed grounds? The insurers say, you can hold the Secretary of State to a higher level of scrutiny if she didn't have it in mind at the relevant time. A bit difficult to see how that applies to legislation that's this old. But why does it make any difference? Because it's either a good reason or it's not a good reason. So what difference does it make in any case, and indeed this case, whether it was the reason that the Secretary of State had it in mind at a particular point in history? There's just no logical difference at all. So the court evaluates it on its own substance and on its own merits. And the question is, are the points that are raised in the case, the detailed grounds in the witness statement, and by reference to the statute, good or not? That's what it comes down to. So it's a wrong approach in principle to try and shut out Mr. Towers and shut out indeed my detailed grounds in the way that the insurers do.
I don't think you do say the question is, are they good? You say, are they, should they be judicially reviewed?
Yes, I don't.
You mean...
Are they manifested without reasonable foundation?
Are they unsustainable?
Yes.
Or with whatever width? So it's not the question is, are they good or bad? That's not for us.
No, good is a shorthand for
a bad
lawful.
Word.
Well, a bad word. The question is, are they lawful, fundamentally? But my lady has my point. It is testing the legality by reference to whether they withstand the appropriate level of scrutiny that the court should bring to bear on them, to put it in a more technically correct way. The court asked the insurers whether there was any relevance about the fact that the scheme had been in force for some time. I simply refer the court, perhaps for the court's note, to PI Authorities tab 30, paragraph 77, which is at page 998, judgment of the Grand Chamber. I accept immediately that there are points of distinction between PI and the sorts of schemes there concerning effectively real property, so land law schemes within the United Kingdom, that might not arise here. But at paragraph 77, the Grand Chamber does have regard to the fact that they're talking about legislation which has been on the statute book for a period of time. So the short answer to my Lord Justice Bingaman's question to the insurers, is there any relevance in that respect in terms of the fair balance exercise? We would say there is, and that finds some support from the authorities. The insurers make a point which they say stands in their credit, and it's a point that's advanced in Mr. P's witness statement, which is to this effect. They say that if we relieve them of these liabilities, that will benefit the claimants, because they say that where there are multiple insurers, it's in the economic self-interest of any individual insurer not to settle a claim, because they will thereby trigger accrue liability, which they'll then have to look to other insurers for in due course, and those other insurers might be more inclined to defend. Well, we say that that is a rather unattractive submission insofar as it's premised on a group of insurers not honouring their responsibilities to an injured claimant. So we don't accept that that is something which in fact stands to their credit at all, because it's not the state's responsibility to cajole insurers to honour their contractual obligations. So true it is that they may well be prodded to settle at the appropriate time if we withdrew all of these financial liabilities, but frankly, we do not accept the legitimacy of that. No. And in any event, even if it is put forward as an act of constructive altruism, then we would say that the interests of injured workers are sufficiently represented and protected. So insofar as there are problems that work to the disadvantage of workers, and those are matters which can and will be brought to the attention of Parliament. See Section 3 of the Compensation Act as an example of that. So all of that is known. That particular mischief or problem is not one that is presently troubling Parliament.
But I mean, you could say, I suppose, that it's not just here we have a statute that's actually been on the statute book now for 24 years, but also Parliament did have an opportunity to look at this area when it passed the Compensation Act in 2006.
Yes.
So if there were other issues, I mean, it may or may not have looked at it, but if there were other issues about this scheme that were affected by the way the law had gone, they could have been picked up at that time.
They could have been picked up in 06, but I repeat the point that this is an area of social policy which is of considerable concern to lobby interests. So we know about the ABI on one side of the equation, but on the side of injured employees, this is the bread and butter work of their collective representatives. So the trade unions do this. This is what they...
The snippets from Hansard you invited us to read.
Yes.
You had in the House of Lords, you had the rival interests of the ABI from Viscount Chancellor and from Baroness, I can't remember her name now, Trade Union of Camden.
Yes, so Baroness Hollis back in the 1990s.
Yeah, and she was an ex-trade union
yes.
official. Yeah.
Absolutely so. And
you can see the rival contentions.
One can see the rival contentions, absolutely so. So we say effectively that they're in a position to look after their own interests, and if there is mischief or social problems arising from all of this, then it is not going to escape the attention of Parliament. The insurers then took the court, and this is a substantial part of their submissions, through a number of the common law authorities. And the way in which the insurers do that is rather revealing, because the authorities are described as being victim-friendly or otherwise. And we say with respect that all of that simply demonstrates a wholly insurer-centric view of the world, in which every single issue that arises in terms of the case law falls to be determined by reference to whether it's in the interests of an insurer or not, who has taken premium on policy terms. And this appears to actually demonstrate what the overall rationale of the insurer's position is. Because if one goes to AXA, for example, that clearly involved a species of court-made liabilities that didn't previously exist. The insurers fight that to the Supreme Court, as of course is their prerogative. But the reason why AXA is accepted and the present scheme is not accepted is because in the insurer's mind, they are on risk in AXA, and therefore it's acceptable because they've had premium and it's within the four corners of the policy. Now, they might not like the fact that it comes out of court-made developments in the law, but they can rationalise it because they say they're on risk. That's presumably why they don't take it to Strasbourg. And that can be contrasted then with this scheme, where they say, well, we're not on risk, and we never were, and that's why it's so objectionable. So Mr. Kent says, look at the sample policies. We have never been on risk, not even arguably, and therefore we cannot tolerate the sorts of liabilities that we're being confronted with here. But that is not the perspective of the Secretary of State. The Secretary of State does not approach all of this by reference to the question of, were you on risk, did you take premium? The Secretary of State's vista is far wider because she is having regard to the insurers, the insureds, tortfeasors, the victims, and taxpayers. So having regard to all of those, not just what the policies say, the Secretary of State is reaching a considered view as to what is in the best interests of society.
Well, it's not the Secretary of State, it's Parliament.
My Lord, but for one...
It's quite an important distinction.
It is always...
Because the deference that we give, proper deference we give to the executive is different to the proper deference that we give to the legislature.
Yeah, well, it can be, yes.
Not can be, is.
Well, it's a point in SC, but I accept the fundamental substance of the point that's being put to me.
I'm not talking about hung up on it, but I mean, the fact of the matter is what we're really focusing on, what we're being asked to consider is the legality of the legislation as it is applied in circumstances where there isn't a discretion. So we're not in a discretionary area where the Secretary of State has discretion as to how to apply the legislation.
So I act for the Secretary of State, and the views of the Secretary of State that I'm putting forward here are effectively informed, of course, by Parliament's views too. So the Secretary of State shares the views that one can discern about Parliament. I can say what Parliament's view is because we've got the statute. But I can also say what the Secretary of State's view, who is my client, is, as set out in her argument.
Yeah.
But the short point is that we say that there is no principle that a concluded contract of insurance has some special protected status under the Convention, which means that it can never be the subject of interference because either you can't pass on the costs in terms of premium or you can't do something else, which is fundamentally where one ends up with the insurer's argument. Short point about what's social remedial legislation and what's high social policy. It respectfully makes no difference. Aspects of this legislation are perhaps better described as social remedial legislation. See contributory negligence example my Lord Justice Dingemans gave. But the other aspects, so situations 2 and 3, they are in the realms of high social policy, notwithstanding the fact that they're not remedial social policy, because they're effectively considering a form of revenue raising in a particular way and using that money for the purposes of welfare. It's all recycled into the welfare budget for what it's worth. But even if it went into general resources, it would make no difference. So it doesn't really matter whether the correct description is social remedial, high social policy, or both at the same time in different aspects of the statute. There's no different test when it comes to margin for either of those different categories. The insurers repeatedly say, well, the state's just increasing the prize, points to that effect. Well, again, that's not the perspective of my client. My client does not see the recovery of benefits that she has paid out to injured claimants as being a prize. In an ideal world, there would be no claims on public resources by those injured claimants. But regrettably, we're not in that position because we continue to have the injuries and diseases as a result of tortious negligence. Just to clarify, if I have not done so far, the position in respect of the order and limitation, I didn't show the court my consequential skeleton, so that is behind tab, so page 212 of the bundle.
Sorry, which tab's it behind?
15.
15.
Yes, thank you very much.
Yeah.
So just in terms of what our position was, because of course we do not welcome judicial criticism, if there's going to be some, then I want to be clear about the factual footing for it. We resisted the entirety of the order that was made on the basis that, having lost on liability, our position was declaration simpliciter following Matheson, PTA and nothing else. But that was our position. So we were not party to any hiving off to the Chancery Division, as has now in fact happened. We were of the position that there are clearly unresolved issues that require resolution in the administrative court, and they were substantial issues. So
Yeah, that's paragraph 18 of yours, go.
yes, so
And you were saying, well, this shouldn't be transferred to the Chancery Division, it should remain in the administrative court.
absolutely so. So insofar as we didn't demur from the point about a damages assessment, that was the point I made in my initial submissions. That was insofar as there is going to be a form of account before a Chancery Master, but not shorter than that. We have got into an unsatisfactory position now, and I accept that entirely in terms of what the order provides and the basis on which I've lost, and the fact that we're having an appeal before, in fact, all of those further issues have been dealt with. And I accept all of that with the benefit of hindsight to some extent. It might have been more convenient to have that second hearing, but the problem is the judge says that's gone off to the Chancery Division, and then to pursue our appeal before this court. But of course, we're in a position where we say there's an extremely unsatisfactory statement of the law recorded in this judgment, which already people are starting to correspond with us about, and therefore there is a strong public interest in us having this appeal dealt with, because our view is that the conclusions of law as reached in the first judgment and indeed the second judgment are wrong. So that's the reason that we have appealed it without in fact having all of those arguments. But we firmly disagree that that was the right course. It wasn't. It was the wrong course.
What about the fact that the declaration goes back to 2000?
Yes.
And what Mr. Kent says is that you didn't say any different date.
Well, we argued against, we didn't know where the judge was going to go, so reserved judgment at the consequentials hearing as well. So we said, yes.
I understand that, but on the other hand, parties have a duty to cooperate with the court and try and assist in getting the right answer.
You were seeking to persuade the judge not to make a declaration of unlawfulness at all.
Yes.
So just to make a declaration simpliciter.
Yes.
Which wouldn't in fact have required the insertion of any dates.
Correct. So that was our position, declaration simpliciter, because the dates, it is slowly being revealed, are primarily relevant to the financial claims.
Well, I mean, you only needed to read the orders to realise exactly what it was. But
it's too late.
A difficulty I have at the moment is you've got 19.5 saying limitation under the Human Rights Act. The declaration goes all the way back to 2000, so limitations being ignored for that.
Well, my lord, I agree, but by the time we've got the order, there's nothing we can do other than appeal it. So our position was that if the understanding of the law on which we have been proceeding to this date is incorrect, then that's the subject of a declaration simpliciter following Matheson. And thereafter, we know what the correct legal position is subject to any appeal. And financial claims, where limitation becomes primarily significant, although I appreciate it's relevant also to declaratory relief, they then get dealt with in what we would say is an unsatisfactory way, but that's where we ended up. So having lost the argument, we agree with the unsatisfactory nature of it, but it's difficult to see what else we can do other than come and trouble this bench with it.
Where does the judge in consequentials deal with limitation? Paragraph 50, isn't it?
Yes. 50.
And was any argument made that the declaration going back to 2000 would be inconsistent with the Human Rights Act section 7.5?
Well, it's difficult for me to answer precisely on my feet how we formulate that, because we were arguing that that was inconsistent with the logic of the judgment. So we certainly have always had...
Because you were saying it was all later on.
Yes. Yeah. And we have limitation arguments in both of our skeleton arguments. We're saying that, in truth, this is really something that should have been brought within 12 months of. And there's various alternatives, but fundamentally it should be the date on which they say the interference occurs. But then they never said that the interference occurred pre-2000 until we got to the stage of final submissions on remedies, when suddenly we go back in time to 2000 and say, well, actually, Fairchild's nothing to do with all of this. The unlawful interference actually was present ab initio, which was certainly not how the insurers have ever put their case, which was all about how
The impact of Fairchild.
the impact of Fairchild thereafter means that they can no longer reasonably be expected to tolerate these costs, some of which they have been living with since the Act was first brought into force, contribute to negligence.
You're certainly entitled to say they proposed the order that was made.
Yes, absolutely. Subject to any further points of clarification.
Do you want to say anything on the cross appeal that isn't really covered by your...
Well, I suppose there's 2 points. The first is that the hard logic of the judgment does point towards the cross appeal, because it is inexplicable the way that when it ends up in that position.
Can we take it as broadly common ground?
So it's really,
It's all or
if you're
nothing.
right about ground one, then the whole lot goes.
Yes.
If you're wrong about ground one, then Mr. Kent's got a good point.
Well, subject to my Lord Justice Stingman's point, well, where does that impact on fair balance? Because it's a different fair balance
Yes, I
exercise.
follow that point.
Yes.
And that's all part of the fair balance analysis. I agree with that.
But this court then has to carry out the fair balance exercise ultimately with a new set of factual conclusions. But in a sense, my position's got worse then.
And that also goes back to the point you made a moment ago about the backdating, if I can put it that way, to this to 2000.
Yes.
Because it's the point that's made by the European Court in Pi, that nobody made any complaint about any of this until 2019.
Well, quite. It's
Even
a compelling...
Even though on the judge's findings, it was unlawful in 2000.
Yes, and it goes to proportionality then and limitation, because it goes to, well, we're not in Welsh Bill case, we're talking about a prospective bill.
Yeah.
The fact that everybody's made their arrangements, the state, insurers, and indeed everyone else, on a particular factual footing, is significant. Won't necessarily tip the balance. In a core discrimination case, it probably wouldn't, but we're not in that sort of case here. We're talking about an adjustment of rights, property rights, which has occurred many, many years ago. and that adjustment then ought to be considered today. But the fact that it's now been adjusted for 20 years makes it even harder for the insurers to complain about it.
Thank you.
So unless I can insist.
Thank you very much. You dealt with our points. Thank you all for your extremely helpful and illuminating submissions.
Well, may I just make one observation?
Yes.
Because I would only have a reply on our appeal. I don't seek to exercise that right.
No.
Just to clarify, the judge didn't hand down this declaration. There was a lot of toing and froing of drafting after we saw the consequential judgment. It's not quite true to say that it sort of came out of nowhere.
Yeah. Okay.
But respectfully, I can't do anything other than cooperate and try and implement what the judge has concluded. So
I follow all that. Right. So we will reserve judgment, and you will receive it in draft in the usual way for any type of graphical errors to be picked up. Not for re-arguing, please. And if you could please endeavour to agree a form of order before hand down. If for some reason it's not possible to agree a form of order, then written submissions before hand down, please.
Including all the dates. Including all the dates.
Including all the dates. Quite. Anyway, thank you again.
All right.